Hi, everyone. Good afternoon. Welcome to our webinar, Advocacy Tools and Successful Practices to Protect Residents from Nursing Facility-Initiated Discharges. Just so you know, all attendees are muted. If you have any questions, if you drag your mouse down to the bottom of your screen, there's a little icon that says Q&A, and there's also one that says Chat. So if you have any questions, please put them in the Q&A. If you put them in the chat, we'll probably see them too, but to guarantee it, put it in the Q&A, and we'll do our best to answer those at the end of the presentations. Next slide, please. The purpose of today's training is to help enhance your understanding of the revised federal nursing facility regulations and guidance, learn new ways to apply the revised regulations and guidance to 3 common reasons for discharge, to hear about how Ombudsman programs and legal services can work together at both the state and the local level to address this issue, and to highlight some project state successes, challenges, and our project outcomes. We don't have time today to provide examples of all of the important work done by the project states, but Jamie will review some of the key points, and I'll talk more about the project next. Our presenters today include Robin Grant, Director of Public Policy and Advocacy for the National Consumer Voice for Quality Long-Term Care, Eric Carlson, Directing Attorney for Justice and Aging, and Jamie Freshy, she's a NORC consultant. Next slide, please. As you may know, complaints regarding nursing facility-initiated discharges have been the most common complaint received by Ombudsman programs across the country for the last 7 years. In 2017, about 7% of all nursing home complaints were related to discharges. Despite regulatory protections against inappropriate facility-initiated discharges, they still occur, and Ombudsman programs have shared their need to have more advocacy tools, education, and collaboration to address this issue. Thanks to a supplemental grant from the Administration for Community Living, NORC launched a project last October, titled Ombudsman Learning Collaborative to Protect Residents Against Nursing Facility-Initiated Discharges, in order to enhance the effectiveness of Ombudsman program advocacy related to this issue. For this project, the Consumer Voice, through NORC, has provided in-depth technical assistance and training for 7 project states. Those programs are DC, Louisiana, Mississippi, Nevada, Oklahoma, Ohio, and Pennsylvania. We held monthly TA calls with all the project states, held 1 training webinar, and hosted 3 peer-to-peer learning roundtables, with the 4th and final roundtable scheduled during the Consumer Voice Conference in November. This webinar is also part of the project, and as Jamie will share later, we'll also have a resource that will be shared with the entire network. Attendees for today's webinar include state ombudsmen, representatives of the office, legal assistance developers, and legal assistance providers. We're also working with the National Center on Law and Elder Rights, NCLR, through Justice and Aging for this project, and as you heard, you'll hear from Eric Carlson later in this presentation. Next slide, please. Since this training is part of the project, we want to see if the training increases the knowledge of our attendees on this topic. So before Robin's presentation, we're going to launch a very brief pre-test poll. We won't share the answers on the screen, as they're for our own internal reference, and the post-test poll will have the same questions, but we'd appreciate it if you could answer these 5 brief questions to the best of your ability. Katie, go ahead and launch the poll, please. And Katie, when it looks like it's about 75% of folks responding, we can go ahead and close it out. Okay, let's go ahead and close it out. Thank you. And go to the next slide, please. So now I'd like to pass it over to Robin Grant, Director of Public Policy and Advocacy for Consumer Voice, to talk about advocacy tools and strategies to address 3 common reasons for discharge. Thank you, Robin.
Thanks, Amity, and I want to say good afternoon to all of you. As Amity said, I'm going to talk about advocacy tools and strategies, and specifically I'm going to discuss regulatory tools and strategies and how you can use them, 1, when the facility says it can't meet the resident's needs, 2, when the facility says the resident is endangering others, and 3, in cases of non-payment. And then I'm also going to talk about some procedural requirements that you can apply to any reason for discharge. Next slide. So I want to begin with an overview of what I mean by regulatory tools and what they are. So there are 5 basic tools. The first one is one I know that you're very familiar with, and that's the federal nursing home regulations, which technically are called requirements of participation. These regulations implement the federal nursing home reform law and are what the facility must comply with in order to receive funding from the Medicare and/or Medicaid programs. In addition to the regulations, there's the guidance, and this is sometimes called the interpretive guidelines. Surveyors use the guidance to interpret and clarify what the regs mean and to determine if a facility is complying with federal requirements. Next slide, please. My guess is that you're fairly familiar or very familiar with the regulations and the guidance, and maybe not so familiar with the remaining 3 regulatory tools. So next, there are critical element pathways. And these are new and were introduced when changes were made to the survey process in 2016. So the pathways help direct the surveyor's inspection and help to identify points for them to observe, questions for them to ask, and records for them to review. So they're similar in many ways to guidance. There are also investigative protocols, procedures, and probes. There are several areas that don't have a pathway. There's a finite number of pathways that have been created. When there isn't a pathway, surveyors are instructed to use the guidelines along with these investigative protocols, procedures, and probes. And again, they tell surveyors what to look for, what to ask, and what to review. The 5th and last tool that we want to add to your regulatory toolbox today are the key elements of non-compliance. So these are the main points that surveyors focus on in determining if there is a deficiency. And often, if one or more of these key elements is not present, if the facility has not complied with one or more elements, surveyors are directed to cite a deficiency for that particular regulation. So like the critical element pathways, these are, I guess I would say, new-ish, and were also implemented with the 2016 changes in the survey process. So where do you find these wonderful regulatory tools? It's almost, but not quite, one-stop shopping. Next slide, please. So you'll find everything except the critical element pathways in what's called the State Operations Manual, Appendix PP, Guidance to Surveyors for Long-Term Care Facilities. And boy, those feds have a way with names, don't they? On the slide, you'll see what the first page of Appendix PP looks like. And I just want to give you a warning. Appendix PP is ginormous. It's approximately 700 pages. So consider yourself warned if you start to print it. Do not print it if you can avoid it. Next slide, please. So in Appendix PP, you'll find the regs and the guidance. And so on the left side of this slide, you'll see at the top a regulation. And in this particular case, it's the regulation about orientation for transfer or discharge. And then below, you'll see the guidance for that regulation. So that's how it flows throughout Appendix PP. But Appendix PP also includes the investigative protocols, procedures, probes, and the key elements of noncompliance. And again, just to give you a sense of what they look like, on the right side of the slide is an example of an investigative protocol, and then at the bottom you see an example of key elements of noncompliance. So the only tool that is not included in Appendix PP is the critical element pathways. Next slide. So here is an example of what one critical element pathway looks like. This is a pathway for behavioral and emotional status. And I will say that this is just one page. They tend to be about, maybe 5 to 6 or so pages, roughly. Next slide, please. And on this slide, I've given you the links to Appendix PP and then where you can find the critical element pathways. The pathways are located on a general CMS webpage, and you'll have to kind of scroll through to look for them, but they are there. So now that you know what regulatory tools you have, we're going to look at how you can use them to advocate for residents who are facing facility-initiated discharges. I knew I could get that out eventually. As I move through this part of the presentation, you'll see references to specific pages in Appendix PP. And I want to note that those page numbers come from the version of Appendix PP that I have indicated on this slide. You'll also, next slide, please. So you'll also see references throughout the presentation to a handout, and that will have page numbers too. And that refers to this handout that you see on the slide, and we have made that available to you. This is an excerpt from the full Appendix PP. It's the transfer discharge section only, and unlike the full Appendix PP, this is only 30 pages and actually is quite useful to print off and comes in really handy. So as I said earlier, we're going to look at 3 scenarios that represent common reasons for discharge and how you can use the 5 regulatory tools to protect residents from facility-initiated discharge. In all of these scenarios, you should assume 2 things. 1, that you have resident consent and are doing what the resident wants, and 2, that you've already investigated the situation and gathered the facts. So with that, let's go ahead and get started with our first scenario. Next slide, please. So the first common reason for discharge is that the resident's welfare and needs cannot be met in the facility. So here's the scenario. Mr. W has a traumatic brain injury and has difficulty thinking, understanding, and concentrating. He is impulsive, restless, and verbally aggressive. The facility issued a 30-day notice stating they cannot meet his needs. Mr. W does not want to leave the nursing home and requests Ombudsman assistance. So in this scenario, there are 2 things that you want to accomplish. Next slide. First, you want to protect Mr. W from being evicted during the 30-day notice period. And perhaps the best way to do this is to recommend to Mr. W that he appeal. And that's because if he appeals, you can apply the regulation you see on the slide that says that the facility cannot transfer or discharge a resident while the appeal is pending, except in certain situations. And you can also apply the guidance, which says the same thing. So the second thing you want to accomplish is to get the facility to permit Mr. W to remain in the facility. And to do that, you need to contest the discharge itself and make the case for why Mr. W must be allowed to stay. So there are a number of arguments that you can make using the regulatory tools. Next slide, please. So first up, under F620, the regulations say that the facility must disclose service limitations prior to admission. So this means that if there are limitations in terms of what the facility can provide that might make it difficult to meet the needs of a resident, those limitations have to be disclosed. And the guidance then adds detail to this by saying, if a facility has limitations in the type of medical care it can provide, this information must be communicated prior to admission. So here's how you could use this reg to advocate on behalf of Mr. W. If, in his case, you determine after your investigation that no service limitations were disclosed to him or his representative, you can point out that Mr. W had traumatic brain injury at the time of admission, and a common symptom of TBI is aggressive behavior. However, the facility didn't disclose any service limitations in caring for someone with TBI. Therefore, it presented itself as being equipped to provide the care that someone with TBI like Mr. W needs. Next slide, please. So there's also guidance, now this is not a regulation, but guidance that, among other things, says facilities are required to determine their capacity and capability to care for the residents they admit. Therefore, facilities should not admit residents whose needs they cannot meet based on the facility assessment. So very briefly, the facility assessment is an evaluation that a facility has to make of all its resources in order to determine what it needs to competently care for its residents. So that's resources are things like the number of residents, the number of staff they have, and other things. So you can use this guidance then to advocate that because facilities should only admit residents whose needs they determine they can meet, the fact that the facility admitted Mr. W, an individual with TBI, means that the facility determined that it has the capacity and capability to care for him. And the behaviors that he's exhibiting are not atypical of TBI and should have been factored in to the nursing home's decision to admit. Next slide. There are also a couple of arguments related to documentation that you can apply. First, and this has been the case for a long time, the requirements say that the resident's physician must document that the resident's needs can't be met. So check to see if that's who did the documentation, and if not, if it wasn't the resident's physician, the requirements have not been met. Second, something that's different and actually quite good under the 2016 regs is that if the facility is saying it can't meet the needs of the resident, it has to comply with very specific documentation requirements. So on page 156 in your handout, you'll see the full regulation. The facility has to document the specific resident needs that cannot be met, the facility's attempts to meet the resident's needs, and the service or services that are available at the receiving facility that will meet the resident's needs. So if there's not documentation about all three of those points, you can argue that the requirements for discharge due to not meeting the resident's needs haven't been met, and the discharge is not permissible. Next slide, please. I think one of the best approaches I've found to use when the facility says it can't meet the resident's needs is to determine if the facility has done all that it's required to do as part of meeting a resident's needs. So in other words, did it follow all the applicable and key provisions? What you want to do is review all the regulatory tools, and if you find that the facility failed to meet certain requirements, If it hasn't done everything it's supposed to do, or it hasn't done them correctly or fully, you can argue that it's premature for a facility to say it can't meet the residents' needs, which in turn means the reason for discharge is invalid. Now, there are a whole host of requirements that we can look at that a facility has to follow in order to meet a resident's needs. But I'm going to focus just on two, and those are the requirements for care planning and for behavioral health services. Next slide. And let's go ahead and start with care planning. The importance of the care plan just can't be stressed enough. I mean, the care plan is the foundation of the resident's care. It's how the resident's needs will be met. So you can argue that the facility's contention that it can't meet the resident's needs is not valid if it hasn't complied with all of the care plan provisions. In Appendix PP, you'll find the care planning provisions under F656 and F657. We don't have time to go through all the requirements, but I'm going to just highlight what I consider to be 5 fundamental components of the care planning process. And as I discuss each of these elements, you'll see on the slide the specific regulation, guidance, and or investigative summary of probes that that element is based on. Okay. So the first component of the process is whether Mr. W's care plan is person-centered. Does the care plan address Mr. W's very individual needs? And next slide. As part of being person-centered, does the care plan reflect Mr. W's preferences and choices? For instance, are his choices incorporated into his actual daily care and his life at the facility? Has the facility included in the care plan the aspects of Mr. W's life that are important to him? Next slide. The second component of the care planning process that I want to highlight is whether the care plan identifies specific and appropriate intervention to meet the resident's needs. So in Mr. W's case, for example, are there interventions to help address his impulsiveness, his restlessness, and the verbal aggression that they've identified? And are these interventions tailored to meet his needs in a way that will support him and work for him? Third component to look at is if the care plan has actually been carried out. And I know that that sounds really basic, but if the care plan is not put into is not operationalized, it's just words on a piece of paper. So there are actually regulations that speak to this, and you want to look at all the points of a care plan. You want to look and see whether not only was it carried out, but was it carried out the way it was supposed to be? Were things done when they were supposed to be done? So all aspects of what actually carrying out or implementing a care plan entail. Next slide, please. You also want to look at whether the care plan was carried out consistently. The regulatory tool that supports this component is actually part of the investigative summary and probes, and it specifically tells surveyors to look for evidence that the care plan interventions were implemented consistently across all shifts. So if the way the care plan has been followed is hit and miss, sometimes it's done, sometimes it's not, the facility has not done what it's supposed to do. So the fifth essential element, and the last one I want to cover of the care planning process, is to evaluate whether the care plan is working and revise it if it's not. This is vitally important. The facility is not in compliance if it has not revised its approach when the interventions in the care plan are not working. So stepping back, if one or more of these 5 components has not been appropriately implemented, you should assert that the facility is not doing all that it's required to do to try to meet the needs of the resident, and you should argue that discharge is not permissible. Next slide, please. So I spent a fair amount of time on care planning because it is so essential, but because TBI is certainly a condition that qualifies for behavioral health services, you can and should use the behavioral health services regulations in your advocacy for Mr. W. So the first regulation you can use is F740. This is very global. It says that the facility is responsible for providing appropriate behavioral health care and services so that each resident can reach his or her highest level of well-being. So you want to look to see what behavioral care and services were provided to Mr. W. Were any behavioral care and services provided? In addition, under another regulation, this is F742, if a resident is diagnosed with a mental disorder, and that's the case here with Mr. W., the facility has to make sure that the resident receives treatment and services to correct the assessed problem or to help reach his or her highest possible level of functioning. So find out if that happened. Did the facility provide Mr. W. with treatment and services to try to correct the assessed problem? There are two additional regulatory tools that you can use to determine if the facility is doing what is necessary to provide appropriate behavioral health care and services. Next slide, please. And I just want to point these two tools out to you very quickly. Here you'll see the investigative protocol for a record review. And this has to do with F742. And on this slide, you can see that there are really some great points that you can use. For instance, just as an example, it talks about, do you see in the record, does it indicate that care and services outlined in the care plan are effective in decreasing the resident's expressions or indications of distress? If not, is the plan reassessed and intervention approaches revised? So this gives you, points that you can apply and think some leverage here. The second regulatory tool, and I think we need to move to the next slide, please. So this is an example of using key elements of non-compliance. This also includes excellent points that you may be able to use in making the case, again, that the facility did not do what is required to do to meet the residents' needs. Next slide. And just lastly, the final requirement I want to cover in the behavioral health section is the regulation about having a sufficient number of staff to provide behavioral services and requiring that those staff members have the training, the skills, knowledge, competence to care for residents who have mental disorders. So depending on what your investigation finds, you may be able to apply these requirements to argue that the issue is not that the facility can't meet Mr. W's needs, but that the facility has not made sure that its staff has the necessary knowledge to care for someone with traumatic brain injury. So those are some of the tools that you can apply for when the facility is saying it can't meet the residents' needs. We're going to now move on to the second scenario. So next slide, please. And here we're going to look at the reason for discharge related to the safety of individuals in the facility is endangered due to the clinical or behavioral status of the resident. So here's the scenario. Mrs. J has a diagnosis of Lewy body dementia and has hallucinations that cause her to become scared and combative. Recently, Mrs. J became frightened in the dining room on several occasions. She then struck another resident in the dining room and was immediately transferred to the hospital. Mrs. J received treatment and was in the hospital for a few days. When she was ready to go back to the nursing home, the facility issued a notice of discharge. Mrs. J has asked for Ombudsman assistance. Next slide, please. So what's going on here is that what started off as a transfer is now a facility-initiated discharge. And that means, as you can see from the regs and the guidance on the slide, that the nursing home has to comply with all the requirements of a discharge, and that includes giving notice. Next slide, please. So like the first scenario, there are two problems that need to be addressed here. The most time-sensitive concern is getting Mrs. J back into the nursing home. First, because it's harder for a person to be discharged when they're physically in the facility. And also because if she stays in the hospital, she's very likely to be sent to another nursing home by the hospital, which is going to subject her to possible effects of transfer trauma. And she's going to end up where she may not want to be. So now, as you all know, usually what happens in this scenario is that when you argue that the facility needs to take the resident back, the facility is going to say that the resident is a danger to others because she hit another resident and they won't allow her to return to the facility. So the good news is that there's actually really good guidance that you can use to counter that argument. And I'm actually going to read some of that language here because I think it is so important. So you can see on the slide, it says, a facility may have concerns about permitting a resident to return to the facility after a hospital stay due to the resident's clinical or behavioral condition at the time of transfer. The facility must not evaluate the resident based on their condition when originally transferred to the hospital. So that is just really valuable guidance. The whole point is that the resident went to the hospital for treatment. Once he or she has had that treatment and the facility is ready to discharge, her condition is likely to be completely different. So the facility can't just conclude, oh, the resident is still a danger to others. It has to evaluate the resident's condition. And that evaluation has to include certain elements that actually have to be documented in the resident's record. Now, you can see those elements on this slide, so I really want to draw your attention to those. And I want to highlight the second point, which requires that the facility obtain an accurate status of the resident's condition, and that's at the time when the resident is ready to return to the facility. So again, this is the status at the end after treatment, not at the time of transfer. Next slide, please. Another approach you can take to try to get Mrs. J back in the facility is for her to appeal the discharge. So you can see on the slide that the guidance clearly states that a facility must allow the resident to return pending their appeal. Of course, the kicker language here is that it does say that the resident, the facility doesn't have to take the resident back if the resident is a danger to the health or safety of others, which of course is exactly what the facility is going to argue in Mrs. J's case. But again, you can see on the slide similar guidance to what we just looked at. The facility's determination to not permit a resident return while an appeal of the resident's discharge is pending must not be based on the resident's condition when originally transferred to the hospital. So this loops you back to the facility having to evaluate the resident's condition after hospitalization. Next slide. Okay, one more tool to use in getting Mrs. J back into the facility is this critical element pathway for hospitalization. The pathway is supposed to be used for several reasons, and one of them is to evaluate compliance with requirements surrounding transfer and discharge. So, for instance, if the, let's see, what you don't see here, I'm sorry, this is just one page of it, but if you do go and look at the actual critical element pathway on one of its pages, page 4, surveyors are directed to cite a deficiency if the answer is no to any of these questions. And one of the questions is, was a resident who appealed their discharge permitted to return to the nursing home while their appeal was pending, unless there was evidence that the resident's return would pose a health or safety risk to individuals in the facility, or there was no bed. So the point is that this just gives you another tool to support your argument that the resident has the right to return to the facility pending the appeal. So the second concern in this scenario is obviously contesting the reason for the discharge. So let's look at the regulatory tools you can use. Next slide, please. Oh, you're there. Perfect. First of all, let me just add that you certainly want to use the care planning regulations that we covered already. Those are 100% applicable here. But I think the regs that are particularly helpful, here are the part of the behavioral health service regs that say that the facility must provide the treatment and services needed for a resident with dementia to meet his or her highest level of functioning and well-being. So in addition to this regulation, there is guidance that you can use. There are key elements of noncompliance. I encourage you to spend some time looking at all of that because I think there are things in there that you can definitely apply. Next slide, please. And I just also want to point out to you that there is a dementia care critical element pathway that I think can be incredibly helpful here. So I would just, again, encourage you to read through it, and if the facility has not complied with any of those steps, you can argue that they have not adequately provided care and treatment and services for dementia. Next slide, please. So finally, you might be able to apply the training requirements in this scenario. The regs mandate that all staff have to receive training on dementia management. So based on what you learn in your investigation, you might be able to claim that the facility didn't provide training, didn't provide enough training, or didn't provide training often enough, and that had they done so, Mrs. J's behavior might have been prevented. So just another approach. Next slide, please. So the last reason for discharge that we want to look at is when the resident has failed to pay after reasonable and appropriate notice. So our scenario involves Mrs. S, who had been paying privately for her nursing home stay, but has exhausted her financial resources. Her family helped her complete and submit a Medicaid application, but Mrs. S has not heard if her application has been approved. The facility has not been paid for 2 months and has issued a discharge notice, and Mrs. S has asked the Ombudsman for help. I think you've probably all had experience enough with regs to know that they are rarely black and white, a lot of gray, they leave a lot unaddressed, but you know, in this case, with the regs related to discharge and how it applies to Medicaid, they are for once crystal clear. Next slide. So the regulation says that you only have non-payment related to Medicaid under 2 circumstances. 1, the resident doesn't submit an application to Medicaid at all, or the resident has submitted an application to Medicaid, the application was denied, and then at that point, the resident doesn't pay for his or her stay. So you do not have non-payment if the application has been turned in. And as the guidance on this slide says, a resident cannot be discharged for non-payment while their Medicaid eligibility is pending. So in this scenario, you would argue that the discharge is invalid because the resident's Medicaid application has been submitted and her Medicaid eligibility is pending, and that all means non-payment has not occurred. Next slide. So I just want to point out some other guidance that can be helpful in cases where the facility is claiming the resident has failed to pay. Sometimes the resident's Medicaid application is denied, but the resident appeals the denial and is waiting for the decision. So in that case, this guidance says there is no non-payment while the decision is pending, so the resident can't be discharged. Next slide, please. And then also, if a private pay resident runs out of money, the guidance says it's the responsibility of the facility to notify the resident of their change in payment status, and the facility should ensure the resident has the necessary assistance to submit any third-party paperwork. So that means an application to Medicaid. So the facility can't just be passive. If it has done nothing, if it hasn't told the resident about their change in status, if they haven't done anything to try to help, then you can argue that they haven't done what they need to do to help the resident. So I just have a couple of minutes left. So let me just say that I've been talking about substantive points up to this point, and those are arguments you can make in contesting the discharge with the scenarios that we've talked about, but there are also procedural arguments. Next slide, please. These arguments have to do with whether the nursing home is actually following the process that the regulations mandate. And this is about looking to see if the I's are dotted, or you're actually looking to see if the I's aren't dotted and the T's aren't crossed, because then you can argue that the proposed discharge is invalid and the facility needs to rescind the notice, or if you're in an appeal, you can argue the discharge should be dismissed on procedural grounds. So just really quickly, next slide, please. Here are just some of the procedural things to look at. Look at what's in the notice. If it doesn't have each of these points listed here, it should be considered invalid. And also, I would add that you should look to see if the information is actually accurate and correct. And if it's not, that should be considered, the notice should be considered invalid as well. Next slide. Also want to make sure the notice includes, who is notified. You want to look at the timing, was the 30 days given? And lastly, in terms of the notice, look to see if there have been any changes in the notice, because there is a regulation that says the facility has to update the recipients of the notice if there has been a change in information. And one of the most significant changes that we find is the one that relates to the discharge location. And there is guidance that's really important to note that says if there has been a significant change, and that includes the location, that the notice must be reissued and the 30-day clock restarted. So that can be a real advocacy tool. Next slide, please. And then finally, use a fine-tooth comb to look through all the documentation to make sure that all the documentation that is required is absolutely there, and that, to the extent you can, that it's accurate. Next slide, please. I'm just trying to fly through this. So there's documentation related to the reasons for the transfer, and also discharge planning regulations have to be followed. So look for documentation about that. That's part of what must be done in order to discharge. Okay, so last slide. So again, just if anything is missing or inconsistent, doesn't follow the requirements, use that and argue on procedural grounds that the discharge is not valid. And I would say that the same thing should go for substantive arguments too. If the facility has not followed all the regulations, if it hasn't done everything it's required to do to care for the resident, the proposed discharge should be considered invalid. So in closing, next slide. Just want to give you some information about how to connect with Consumer Voice in general, and please feel free to also contact me personally. And now I'm delighted to turn things over to Eric.
Actually, if you don't mind, Eric, right before you go, this is Amity. We've had several people ask, and I've been posting it in the chat box. If you can't see those, please check the chat box. Yes, the webinar is being recorded. The recording will be available after today's presentation. The slides, materials, links to the resources that Robin mentioned will also be emailed to all the webinar registrants. If you look in the chat box, I included links to all of the resources that Robin reviewed, and I'll post them again shortly because those that joined late may not have seen those. So hope that helps, and it's now turned over to you. Thanks, Eric. Thanks, Robin.
Thanks, Amity. Next slide, please. So obviously, I'm going to talk a little more about program development as opposed to the substantive law, and I would like to think that this is going to be relevant to ombudsman programs and for legal services programs and for others. We're in this together, and legal services programs have certain skills and access, and ombudsman programs have certain skills and access, and the trick is to figure out how to work together to be as productive as possible and as useful as possible to the nursing facility residents that really do need some assistance, can benefit from it. I'm from Justice and Aging. Our mission is to use the law to benefit older people of limited resources. Next slide, please. And I'll take a step back into the Wayback Machine here. I started my legal career, essentially. I'd been out of law school a small handful of years when I was hired to run a direct service legal aid program focused on nursing facility residents. And we had a program, we had some funding, and once I started the job, I got the sense that we didn't have a whole lot more than that. There wasn't a lot of people knocking on my door or calling me up on the phone, and so I spent some significant amount of time for those first weeks, months, a couple of years in trying to build up the program and to make myself useful, to benefit nursing facility residents, to fulfill the mission of the job that I had. And these are some observations on why it's tricky. You're dealing with nursing facility residents who have some limitations, either physically or due to dementia, and so they're less likely than other legal services clients probably to give you a phone call or to show up during the intake that the office might offer. Also, nursing facility laws are unfamiliar to the vast majority of the population, and I think that people don't have as good of instincts because of that. Just an example, if you told the average person on the street that that a landlord could just go to a tenant and say, get out within 24 hours, the average person on the street, I think, would say, well, that doesn't sound quite right. Yeah, they don't have the right to do that, do they? But if you asked that same person whether that was true in a nursing facility setting, they might say, well, maybe, that they may not consider that out of line, but as all of us know, because of the program, that material that Robin just presented, of course, that's completely wrong. So there's a real unfamiliarity with laws by the residents, by the family members, by consumers in general. They don't know enough to appeal things sometimes, or to push back. And then moving on to the next point, even if they do have some inclination to push back, some sense of, well, this seems wrong here, there's some pressure that makes it more difficult for folks to do that. They're living in the nursing facility, for example. They're receiving care 24/7 from the same people that might be involved in this dispute going forward. So just because of the psychology of that, people oftentimes are hesitant to say anything. They should, and I when I talk to consumers, to residents, to family members, I always explain why the better course of action is to push back, to protect yourself. But be that as it may, I still can recognize the inclination of people to be a little bit timid, a little bit reticent, a little bit cautious in pushing back on some of these issues. And then on top of that, there are all the other reasons that people don't get to legal services office or lawyer's office in general. I think all of us who are legal services attorneys know and understand that the clients that we talk to are just the tip of the iceberg, as it were. For every one person we're talking to, there's another 5 or 10 or 15 or whatever the number it is of people who are probably going through a similar problem, but for whatever reason don't get assistance, don't get to a legal services office. So going back to when I started this job, my experience was I could sit in my office and wait for the phone to ring, but the phone didn't ring very often. I need to figure out how to make some progress to accomplish something useful, to raise the profile of the program, to raise the profile of the issues. You can move on to the next slide here. These are a few of the things that I did at that point. I spoke to the local ombudsman program, and this was, I think, having a productive partnership is incredibly valuable, as I think we know of the folks here on the call, that the ombudsman programs have access to nursing facility residents. They're able to go into facilities and talk to them, and so residents who have some issues are likely to see the ombudsman program as the most obvious source of potential assistance. So I spent some significant amount of time talking with the local ombudsman program, but I'll just report, and the folks that were running the program at that point are no longer running the local program. But it was difficult because they were very, for whatever reason, were very hesitant about working with me, and it was and I get some of the issues about confidentiality, but as always in these situations, if the ombudsman has consent from the resident to go forward on something, they should be able to do that. I found the relationship much more difficult than it needed to be. And I'll say in subsequent years, obviously, I've worked with dozens of legal services programs, and I think the one local program I started working with initially was maybe particularly difficult or particularly unwilling to cooperate with legal services programs. So, but the point is, it's an incredibly valuable connection. You need to approach it from a legal services perspective. You need to approach it in the right way. Ideally within the structure of the state aging services, through the legal services development or the aging department and others, you would hope that there'd be some understanding there, some agreements, so that it would be understood throughout the state how to make those relationships work. Other things I did were to publicize the relevant law. And I mentioned a couple minutes ago that people are very unfamiliar with the laws, and because of that, oftentimes they would have very righteous complaints, but wouldn't do anything about them because they didn't know anything about, and I'm not blaming people. How would they know anything about that? And so to address that, I wrote some consumer guides that were very question and answer format, trying to be as reader friendly as possible, and also did as many presentations as I could, both to consumer groups and to aging services groups, networking groups, social worker groups, the groups that are oftentimes convened by local hospitals focusing on aging services, all those sort of venues. And in doing that, part of it was educating people about the substantive law, the sort of things that Robin was talking about, for example, and then also to get our program out there and our willingness to be of assistance on these issues. Next slide, please. Mention the unfamiliar law. Here's some resources. Apologies, some of these are ours or mine, but 25 common nursing home problems and how to resolve them. Long-term care advocacy is a legal treatise that I do for Lexis Publishing. It's a comprehensive resource on legal questions relating to nursing facilities, assisted living, long-term care, Medicaid eligibility, related questions. And then also Consumer Voice, of course, has a plethora of resources. Center for Medicare Advocacy does as well, particularly relating to Medicare coverage issues. Also, the Long-Term Care Community Coalition has a tremendous amount of resources that are directly available from their website. And the same can be said for California Advocates for Nursing Home Reform, with a particular focus on California-specific issues. Next slide, please. Getting back to the collaboration between between Ombudsman programs and legal services programs. In some states, there's less of an issue because the programs are the same. The legal services program is operating the Ombudsman program. Michigan's is one example of that, and Vermont is another. And then moving on to the next slide, there's also a variation on that in Western New York that I'll flag, where they're separate programs, but the Ombudsman program has a formalized arrangement with the legal services program, the Center for Elder Law and Justice, where they're the legal liaison within the Center for Elder Law and Justice, provide specific services that benefit the Ombudsman program and nursing facility residents through trainings, through in-house legal support, and also some legislative and administrative advocacy. Next slide, please. Legal services programs can address a lot of issues in nursing facilities in ways that non-lawyers cannot, in many cases. Transfer and discharge is one example. Trying to get back from a hospital stay when the facility refuses to allow the person to return. A lot of Medicaid eligibility issues. Some of the financial issues, collection actions, for example, and also some related legal issues that arise in the course of a stay in a nursing facility. I'm going to address just one of those here this afternoon, moving on to the next slide, which the heading, and you'll see that we're going to talk about the role of a legal services lawyer to prevent residents from being excluded from nursing facilities after being sent to the hospital. Less cautiously, residents being dumped in hospitals. The next slide, please. There are only 6 reasons to evict a nursing facility resident. Robin mentioned some of these, but these are the 6. Non-payment is mentioned, endangering others' safety or health, the resident needing a higher level of care, that is, the nurse feels supposedly can't meet the person's needs. Robin addressed those, and then also the resident not needing nursing facility care, needing a lesser level of care in the nursing facility going out of business. Next slide, please. There's a couple of laws that relate to the resident trying to get back to the nursing facility after a hospitalization. One, generally under state law, there's a right to hold the bed for a specified number of days, and generally the state Medicaid program has authorization to pay to hold the bed for those limited number of days. It typically would be somewhere between 5 and 10 days, although again, it's going to vary from state to state. Then there's a federal right that applies across the country, a right for mostly Medicaid eligible people to get back to the next available bed regardless of the length of stay, because it doesn't necessarily make sense for an individual or a Medicaid program to pay for an empty bed for a month, let's say. But it does make sense for the federal government to require the nursing facility to let that person in to the next available bed, to the same room if it's available, but if it's not available, the next available room. So moving on to the next slide, the false statement from the nursing facility is, look, you can't come back, we can't meet your needs. And Robin has addressed this in great detail. The facility has an obligation to let the resident to return pending the hearing. Robin talked about all the arguments that can be made to say to the nursing facility, yeah, you have to let this person back in. And I'll say, in my experience, this argument by the facility is almost always false. It may be that the resident is difficult, but it is never the case, in my experience, that they can't meet the person's needs. Because when the nursing facility really can't meet the person's needs, the hospital isn't isn't sending the person back. If they have medical needs that great, nobody has any interest in having the person go back to the nursing facility. So the issue is more when, of course, the resident needs a nursing facility, but the nursing facility sees an opportunity to rid itself of a resident who the facility considers, for whatever reason, to be difficult or more time-consuming. Robin talked about the administrative appeal process. The litigation comes up here. We can move on to the next slide, just because facilities sometimes can be very recalcitrant about this. Either they just are going to wait for the hearing because they figure, well, maybe the hearing will come up in 2 weeks, but the resident will probably be forced to go to a different nursing facility by then, and we're going to end up winning one way or another. Or also sometimes the residents win the hearing and the facility still says they're not going to take the person back, saying essentially to the Survey and Certification Agency, do your worst. We're not taking this person back. And unfortunately, some survey and certification agencies are less than aggressive in pushing back against arguments like that. So this is where a lawyer can file a lawsuit, for example. People who have interest in this, just send me an email. I'll send you some of the sample pleadings I did when I was in a direct service practice. There's generally causes of action under state law, a request for the judge to order that the facility immediately take the person back. And my experience has been that the judges generally get this. It's a lockout. They've seen lockouts before, and they immediately recognize the unfairness of the whole situation. So it's oftentimes an incredibly valuable piece of leverage. A facility may think that they've got all their bases covered because they're prepared to stonewall the licensing and certification agency. They're not really prepared to deal with litigation filed against them. So with that, we can move on to the next slide, which is obviously the contact information and info about justice and aging. I'll pass control over to Jamie.
Thank you so much, Eric, and thank you, Robin, both for your wonderful presentations. I know I certainly appreciate it and have learned a lot. If you could advance to the next slide, please. I have the pleasure of talking with you all about our Learning Collaborative and the project that we have been working with the project states on. And so Amity had given you a brief overview of the project at the very beginning of the webinar, and I'm going to, as I said, give you a brief overview as well, but I'm going to specifically talk about some of the challenges and successes that we've had throughout the project. And I want to go ahead and start with the project challenges. So you can flip to the next slide and then quickly to the next slide after that as well. A lot of what I'm about to say probably will sound very familiar to all of you in terms of the challenges that you're experiencing in your work with transfer and discharge. Some of the things that came out from the project in terms of what the project states indicated as challenges were that states noted a significant amount of information coming in from the facilities, with the new requirement being that all facilities send transfer and discharge notices to the state ombudsman office. Some information that was required to be sent, but also some states were reporting getting information on resident-initiated discharges as well. And while a large amount of notices and transfer logs were coming into state offices, the states quickly realized that not all facilities were sending transfer and discharge notices to the ombudsman program. And so just managing all of the notices and all of that information coming in was proven to be a bit of a challenge. And then the project states had to determine what information do we track? What are we looking for? What kind of information are we wanting to learn and wanting to gain? Who's responsible for tracking? Is that, do I have enough people in my office to assist with the tracking? And also, what is it that states wanted to gain from the tracking? What do we want to learn from gathering all of this information? And unfortunately, some of the project state's current documentation systems are not set up easily to track the information that some states wanted to track. So for instance, consultations with a transfer discharge as a topic, and that was very hard to track. So states then developed another means to track some of the information coming in and some of the information based on the work that they were doing surrounding transfer and discharges. And then finally, in terms of the transfer and discharge information, the project states identified a lack of understanding on the part of facilities about the specific requirements related to notifying the Ombudsman. Next slide, please. Additional project challenges, I'm going to break it out into individual advocacy and systemic advocacy. So some of the project challenges involving individual advocacy was that residents that cannot communicate consent or provide direction. Residents who can't communicate consent are often unable to obtain legal services, and residents with no representatives who cannot direct often have no voice to request a hearing or to be represented in a hearing, and that places a particular challenge both to the resident and to the Ombudsman. We're still finding that some residents are not receiving written notice, or perhaps they were given written notice but only a few days to discharge, so that's not proper notice. In addition, states were reporting that residents are still being sent to the hospital and not accepted back to the facility, something that Eric had just mentioned. And you heard earlier in the presentation from Robin some tips and tools to combat this concern. It still remains a big problem that's potentially very damaging to residents and extremely time-consuming on the part of the Ombudsman to assist residents under these circumstances. And finally, under individual advocacy, a challenge of using behaviors, and I'm using quotations around the word behaviors, as a reason for discharge. Usually that's surrounded by needs can't be met. And that's been a challenge for several reasons. This seems to be a catch-all, whether the facility uses it as an official reason of it cannot meet the needs, as I mentioned, of the resident, or if the resident is a danger to others. So ombudsmen are seeing discharges for not allowing, for example, for not following the smoking policy. I'm going to talk a little bit about that later on, or a behavior contract, or for residents with dementia who are quote-unquote combative. So a significant amount of time goes into investigating these behaviors in preparation for a hearing, as Robin so nicely laid out for you earlier in her presentation. But again, it's extremely time-consuming. In terms of systemic advocacy challenges, some of the states reported that they have outdated or no standardized forms or confusing letters for transfer and discharge notices or requests for a hearing. Part of that is, what happens is when the forms are confusing, individuals such as ombudsmen, residents, family members, even hospital staff are confused about what the notice means. Is this an emergency transfer? Is this actually a discharge? So some of that is still very confusing and has not been clarified throughout the states. And also, we have states reporting a lack of significant penalties for not complying with the regulations. I think we've all heard facilities say that they'll take the tag because there's not enough of a deterrent to follow the regulations. And finally, an overall lack of knowledge of the significant impact discharges have on residents. And we're going to get into some of, we've identified the challenges, but we're going to talk about some of the successes as well. In terms of how the states under this project have handled these particular challenges. Next slide, please. In terms of collaboration in challenges, some states have struggled with collaborating with their own state unit on aging, and several states indicated that working with the state survey agency was a challenge, particularly getting the survey agency to understand that the transfer and discharge identified challenges are more than just a paperwork issue, and that improper or illegal discharges have a huge impact on residents' well-being. Next slide. Under the legal and administrative hearing project challenges, we were finding that it's a challenge when hearings are held via phone. it seems to be that hearings not held in person are often not conducive to residents and really do give an unfair advantage to facilities. Some states had no clear process for hearings, or there was a lack of training on the Ombudsman program's role in a hearing. Another challenge was the lack of access to legal service. And finally, some of the project states had found that some attorneys and administrative law judges lack a solid understanding of federal requirements and resident rights. So now that we've laid out some of the challenges coming into the project and as we still work through them during the project, I'd like to cover some project successes. Next slide, please. And as Amity mentioned at the very beginning of the webinar, we don't have the time, I wish we did, to really celebrate all of the project successes. I was just absolutely overwhelmed by the progress that every single state in the project was making throughout this project, and really do my hat's off to them, and they deserve a lot of kudos for the work that they've done. So again, this is just a snapshot of the project successes that we've had. If you could go to the next, oh, you're already there, sorry. So on tracking transfer and discharge notices, as I mentioned earlier, states have to deal with, you all have to deal with an enormous amount of information coming in. So project states came up with individual processes to track and analyze data coming in from the transfer logs and the discharge notices. And as the project advanced, states determined what new information they wanted to track and analyze. So for example, Ohio found that they had a 54.2% prevalence rate, and of that percentage, 52.69% of the cases are resolved prior to a hearing. They found all that out from tracking. Some of the examples of information tracked, this is a small amount, there are many more different types of information tracked, but here's just a few. For instance, a reason for discharge, the location of the discharge, the facility and or corporation trends, required information, requests for ombudsman assistance. And then once states determined what information they were tracking, then became the analysis of the data and what do you do with that and what are you looking for. So trends were identified and shared with state agencies and program staff. And in some project states, the sharing of data opened the door for stronger collaboration between the Ombudsman program and state agencies. And there were also, the information gained was used to improve Ombudsman training and to determine what in-service training to facility staff was really needed. And the next slide shows an example, a tracking example from Ohio, and what information they found when they were tracking the different proposed reasons for discharge for April through June of 2019. So you can see by far their highest number is for residents who were essentially for non-payment. And so their second most common reason was the facility ceases to operate, but they had an unusual high number of facility closures within that period of time. But this is just a nice snapshot in their this particular quarter for what they were tracking in terms of reasons for discharge. So next slide is the project successes for advocacy. And again, I'm breaking it into systemic and individual advocacy. Oklahoma developed a transfer and discharge pamphlet for residents when they're issued a notice. Nevada had assisted with a bill that was passed requiring all facility types to submit discharge notices to the state ombudsman. And DC's annual review identifies trends in notice deficiencies and shares the information with all long-term care facilities and the licensing and surveying agency to mitigate future violations of federal and state laws. And because of that report, the State Long-Term Care Ombudsman Office had a facility reach out to them to host a district-wide training for all facilities on transfer and discharges. In terms of I wanted to give a brief example of an individual advocacy. And again, this was in the District of Columbia. Their office received 2 notices of involuntary discharge due to residents violating the new smoking policy. After reaching out to the nursing home, the Ombudsman office learned that the nursing home had been cited for safety violations due to resident smoking. Thus, the nursing home had changed its policy and adopted the stance that any and all violations of the policy, such as having a cigarette in your pocket while you walked on the main floor, meant that you were issued a notice of discharge. In both cases, residents who both had limited mobility were being discharged to locations not wheelchair accessible. After reaching out to the facility, it did not appear the notices would be rescinded. So the Ombudsman office filed for fair hearings on behalf of both residents. After further discussion with the regulatory agency and the facility, it was agreed that the facility would withdraw the notices. Also, the facility agreed to review their policy to ensure it did not violate the residents' rights and also did not force residents to be unnecessarily discharged. Next slide. Project successes under collaboration. We're seeing project states utilizing referrals to legal services, reciprocating training with legal services, collaboration with the nursing home associations on the transfer discharge forms, developing MOUs with legal services and the LADs. And you'll see an example, it's a bit hard to read, of the Oklahoma Memorandum of Agreement with the Oklahoma Disability Law Center and the Ombudsman Program, for example. Next slide. Under legal and administrative hearings, in one state, the Medicaid agency has agreed to hear appeals on discharge cases, but prior to this project, in this particular state, residents were not afforded due process on discharges. So next slide. In conclusion, I want to go over the goals and outcomes of the project states. And you can go to the next slide, please. On the left-hand column, you're going to see what the project states' goals were summarized, and on the right-hand side, what the outcomes were from their goals. And as you'll see as we move down, all of the states have met their goals. So the very first one, to manage discharge notices and to learn strategies to collaborate with the state licensing agency. This state developed a process and a tracking tool for incoming transfer and discharge notices. They utilized track data to explain the significance of transfer and discharge concerns to successfully collaborate with state licensing agency, including a memo going out to facilities stressing the regulatory requirements. Another state their goal was to develop methods to increase effectiveness in program advocacy and complaint resolution. Their outcome was that they utilized a team approach between the Ombudsman, they have a staff attorney, and the licensing agency to address the systemic discharge concern that I just mentioned with the smoking that violated residents' rights. And in addition, they are also in the process of developing a model discharge document. This document will be on our resource page once it's finalized. The model discharge document explains facility requirements for transfers and discharge to ensure safe and orderly transfers and discharges to protect residents' health, safety, welfare, and rights with a focus on residents' needs and preferences. And in this state, this is per statute. It's a wonderful resource. A third state's goal was to collaborate with state agencies to develop a fair hearing appeal process and develop uniformity with Ombudsman advocacy throughout the state. And as I had just mentioned on a previous slide, that was successful in this particular state developing a fair hearing process for residents. And they also developed a new procedure for Ombudsman to take a more proactive approach to facility-initiated discharges. Next slide. Another state's goals was to develop and promote education and training assistance for Ombudsman to cross-train with legal services and to track discharge notices. This particular state brought in a subject matter expert to conduct a statewide training for ombudsmen and legal services on administrative hearings, and they are also now tracking notices. Another state's goals was to improve communication with the state survey agency, to develop strategies to challenge complex discharge cases, and to develop a data collection system. This particular state developed a comprehensive data collection system, and they used the information from their data system to take to the state survey agency as well as the regional survey agencies to point out the concerns that the ombudsman are seeing surrounding transfer and discharges. And because they had this concrete information they were able to utilize and to share, it really opened the eyes of the regulators, and they are continuing to share data and the explanations of the meaning behind the data, which has greatly improved communication between the Ombudsman program and the state survey agency. This particular state also brought in a subject matter expert to statewide training to address strategies when working with complex discharge cases. Next slide. Two more. Hang in there with me. So on the project state goals, on the left-hand side, one state had a goal to avert unnecessary discharges and solidify continuity of care. This state conducted training for all ombudsmen about averting discharges, and 100 out of 140 of their discharge cases as of the end of July for fiscal year 19 were averted. So because of that, residents were allowed to remain in their facility, solidifying continuity of care. And finally, the final state's goal was to ensure approach and advocacy towards discharge is most effective and to identify and approach trends and problems related to discharge. This state has achieved an 82.3% resolution rate among discharge complaints within the first 3 quarters of calendar year 19. They've increased frequency of resident contact, so in the first 3 quarters of calendar year 19, the Ombudsman contacted 56% of residents who received notice. Of that 56%, Ombudsman opened cases on 54%. The state office reviews all hearing decisions reports to develop guidance for Ombudsman representatives for hearing preparation, and have identified several common practices by facilities and corporate trends, such as homes pursue a quick and unsafe discharge when a resident receives an adverse PASAR decision or denial, hospital dumping and using notices as a means of collecting payment. And in this particular state, they found that the most common reason for discharge is failure to pay, and the most common proposed location was another nursing facility. So at this time, I think Amity is going to open it up for questions.
Yes. Thanks, Jamie. Okay, so I know that we were really ambitious in trying to fit in a lot of information in an hour-and-a-half long webinar. So I'm going to definitely take some time for questions. If we cannot address all the questions, we have them captured, and we will email the attendees the responses. But just so you know, one attendee asked a good question about including the links to the materials that Robin mentioned in her presentation on the NORC app. So I wanted to call your attention to the NORC app. There already is a page for federal laws and regulations, and that has a link to the SOM, the State Operations Manual, and the nursing home requirements, but we don't have the other materials that she mentioned. So we will add those links to that. So that was a great idea. Okay, so question. If a resident appeals a discharge and the ALJ, so the administrative law judge, upholds the facility's decision to discharge the resident, resident received application for reconsideration. If that application is completed and submitted, does the facility need to keep the resident until that decision is made? Eric or Robin?
I'll take a shot based at what I think the question is driving at. I'm going to define the question as you, the resident, lose the administrative hearing, you appeal it. Do you have a right to stay there pending the appeal on the transfer discharge? And I don't think the regulations or the guidance address that. I think if you were handling that, usually these appeals are made to a court in most states. You're going from an administrative setting to a state court generally, and I think the safer course in that case would be for the attorney for the resident to request an injunction from the state court to make sure that the resident can stay put while the appeal is heard.
Thanks, Eric. So a question for Robin. I think this was it came up off of one of the scenarios. How would you respond to a facility that says we can't meet the resident's needs because the resident's attending physician has said he will no longer care for the resident, and therefore without a physician we can't take care of him?
Okay, well, I guess a number of different things I would say. One, the fact that there is the resident's attending physician can no longer care for the resident certainly is not a permissible reason for transfer. But so there are requirements. The nursing home has to ensure that another physician supervises care when the resident's attending physician is not available. So I guess you could argue that the attending physician is not available, so they have to ensure that there is some doctor there to provide care. Under residents' rights, the right for a resident to choose their attending physician, there is something in the guidance that talks about if a resident's physician is unwilling to continue providing care, that the facility has to assist the resident in finding a replacement. So I would say that the responsibility is on the facility to get a physician, and so they can't meet the needs on the fact that there's no physician, because they have the duty to work with the resident to find one and to make sure there's coverage until that time. The time that there's a replacement.
I'm going to add just 5 seconds. I saw this question coming up and looked up the reg. So it's 43.30. A, the facility must ensure that another physician supervises the medical care of residents when their attending physician is unavailable. So Robin's exactly right. That's the citation.
Thank you. Excellent. And I know this has come up several times because we've received some requests for TA on this issue before. So I am going to cut that off. We actually addressed a lot of the questions online as they were coming in. And so I'm going to go ahead and Katie, if you'll launch the post-test poll. And I do apologize. It looks like I cut that off too quickly last time. So please respond to those questions, and I'll leave it up a little longer than the pre-test poll. It should pop up in the middle of your screen. And then Jamie will take over once the post-test poll is closed and just do a very quick run through of the resources, and all these links will be available after the webinar.
Katie, if you just want to let me know once you get the majority of folks to answer, and you can go ahead and flip to the next slide so I'll know when you're ready for me to begin. That'd be great.
Sure. We're at about 1% right now that have completed it. We're at about 50%, so I'm just going to leave it up for about 10 more seconds.
Okay. Okay, thank you. So very quickly, I wanted to share with you some of the resources that have come out of the project, and there are several. We have all of our webinars available at the link that you see on your screen that we have conducted throughout the project for the project states. And in addition, we have project states resources that they have come up with on their own. For example, their transfer and discharge tracking forms, letters to facilities, their annual quarterly reports. We have the MOUs, guidance to local ombudsman, ombudsman and provider training. We've got wonderful transfer discharge notice flow charts. So we have all of that available to you. And also, we are developing a resource guide that will be available. It's not ready yet, but it will be available in the future for all ombudsmen, and it includes advocacy considerations when working cases of transfers and discharges, advocacy tools and tips. It's going to be a wonderful resource for both skilled and brand new ombudsmen. Next slide. This is just a screenshot of the transfer discharge issue page that you can see where you can go. You've got the link and you can click on the various resources that that our website has to offer. And then the next two slides show you, thank you, the program management regarding nursing home facility transfer discharge notices. Just a reminder that we have a lot of our information from the project on the state long-term care ombudsman side, since they are specific to the state long-term care ombudsman level program management. A reminder for the state ombudsman that this is why they're on the password protected side. So this particular, for the next two slides, are specific to or for the state ombudsman. And finally, we have the training and consumer education materials. Here's some screenshots of those resources, and you have the link below on that. And finally, our contact information is on the next slide. And on the very last slide is additional information with how to connect with the Resource Center. So that's all I have. I appreciate everyone's time and attention to this very important matter. I will turn it over to Amity for any final comments. Thank you.
Thanks, Jamie, and we're only a couple minutes over, so lots of really good information. Thank you so much, Robin and Eric and Jamie, for presenting today. Thank you, ACL, for the supplemental grant that made this project possible. We really appreciate that, and we've enjoyed working with Nickler through Justice and Aging. So last but not least, you can see our contact information here, including information on how to get the NORC app. Please complete the evaluation that should pop up as soon as this webinar closes out. And keep an eye on your inbox. We'll send you links to all these materials. So have a great rest of your day and a good rest of your week. Take care. Thank you. Bye.